Welcome to Mayor Brown's Brexit Snapshot Podcast series. This series is designed to provide insight on the latest legal issues related to the UK's new post-Brexit relationship with the EU and to keep you up to date on changes to the legislative framework. You can subscribe to this podcast series on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
Welcome to episode 4 of our Brexit Snapshot podcast series. I'm Rebecca Timms, the Global PSL for the Antitrust and Competition Practice, and today I'm joined by Warsha Kalé and James Harrison from Mayor Brown's Public Procurement Group.
Hello.
Hello, how's it going?
Good to speak to you both. Today we're going to talk about the immediate changes to UK public procurement that we'll see as a result of Brexit, as well as the UK government's current proposals for a revamped future regime. The UK public procurement regime governing the award of public contracts has been shaped for the last 40 years by EU law. For public authorities, bidders and their advisors, Brexit means that we are all now faced with a different legal framework for procurement in the UK, after being accustomed for so many years to the EU procurement directives. However, there were provisions on public procurement included within the EU-UK Trade and Cooperation Agreement, or TCA, an agreement we've heard a lot about in these podcasts. So this might suggest the UK will not be starting from a completely blank slate. So first, I'm going to ask James, who's joining us from our office in Brussels, to give an overview of the immediate changes brought about by Brexit to the UK public procurement regime. James, we know from our own discussions in episode 1 about retained EU law that EU directives are generally not retained in the UK post-Brexit. So if the EU procurement directives are no longer applicable in the UK, what have they been replaced with?
Yeah, it's a really good question. It's important to remember that the UK regulations which implemented those EU directives still very much stand. And we discussed in episode 1 that they had some tinkering around the edges to make them function properly post-Brexit. But generally, the landscape and the rules that we're all familiar with, they've remained largely unaltered. But having said that, you're absolutely right. Post-Brexit, the UK is no longer bound to apply the EU procurement directives. So instead, the UK's signed up in its own right to the WTO's Government Procurement Agreement, or GPA as we like to call it. And that sets out some minimum standards for procurement processes. So everyone who is hoping for a change to general principles of equal treatment and non-discrimination, you're going to be sorely disappointed. And that's an important point to bear in mind when discussing any future reform of the UK regime. Those minimum standards can't be undermined. The EU has long been a party to the GPA, and so our existing UK regime is already considered compliant with those GPA standards. But only certain public contracts fall within the GPA. There are some very long schedules which set out the exact scope and contract value thresholds of the GPA. But for now, the existing thresholds in the UK regime mirror those set out in the GPA already. Now, outside these areas, the UK is free to set its own rules and thresholds. And this is going to have a big impact for below threshold contracts in particular. And we've already seen that the government's updated its guidance to allow for reservation of contracts to suppliers based on their location. And that clearly wasn't possible before under the UK regime. And it's interesting in the consultation that you're going to be discussing a bit later in the podcast. These changes have already drawn a lot of commentary, and in this respect from the Competition and Markets Authority, on the potential use of very narrow pre-qualification criteria, such as supplier location, which might ultimately lead to a reduction in the supply base available and maybe an increase in bid rigging opportunities. I think the one caveat to all of this is that procurement processes commenced before 11 p.m. on the 31st of December, that magical time and date, will remain subject to the old EU regime. Now, this is really important for framework agreements and any call-off contracts under those agreements, because the EU regime will continue to regulate them until the expiry of the framework. So the EU regime isn't quite dead yet.
I see. That does sound quite a familiar position. So does the TCA change that basic position under the GPA at all?
Absolutely, certainly does. Its effect is broadly to replicate the coverage of the old EU regime. It essentially fills in some of the gaps that the GPA doesn't quite cover. So let's give you some examples. Gas and heat utilities are covered alongside a number of other services like telecoms and education services. But the TCA does cut the other way. It does exclude some services. So in the TCA, these are all types of health and medical related services. And the TCA also offers something of a lifeline to below threshold or non-covered procurement. I hope you can see my air quotes in this podcast. Non-covered procurement, as it's called in the GPA and the TCA. And these prevent the operation of discriminatory processes where the foreign supplier has an establishment in the UK or the EU member state where the procurement is taking place. I think it's going to be really interesting to see how case law develops on the basis of these challenges in particular, especially where UK suppliers based in EU member states could maybe regain access to opportunities and remedies in other EU member states following the logic of the TCA.
So if the legal regime is looking quite similar, how about practical changes? I imagine the contracts won't still be published on the EU platform going forward.
Yeah, that's a key practical change. Unless we're talking about a procurement from the transition period, pre-31st of December, there's no obligation to publish above threshold contracts to the EU official journal or the TED electronic platform. Instead, the UK has created its own platform called Find a Tender, very imaginative, to publish post-Brexit opportunities. Importantly, the government has confirmed this is going to be a clean slate, so nothing's going to be imported from the TED platform, the EU platform, and there's no obligation on authorities to repeat publication of new items from the EU platform on the UK platform. So the cut and short of it is bidders need to keep one eye on the EU platform, especially where they're looking to compete for above threshold covered procurements. More broadly, remedies are preserved under the TCA for above threshold awards. But again, for below threshold contracts, the opportunities for challenge are looking a bit more uncertain. Having said that, how the UK Internal Market Act is going to gel with the post-Brexit landscape remains to be tested. And let's not also forget about Northern Ireland. If the procurement involves a restriction of trade and goods between the EU and Northern Ireland, then we're back to looking at our old friend, the withdrawal agreement, and the Northern Ireland Protocol to hopefully maybe revive some EU treaty-based remedies.
Thanks, James. So now that we've established some key points about the immediate post-Brexit procurement regime, let's look a little further into the future at where the UK regime can go next. The UK government published a green paper in December last year, which sets out what seems to be a radically different approach to the public procurement in the UK. I'm now going to ask Warsha to unpick some of the finer details of the government's suggested new approach. Hi there, Warsha. Many thanks for joining us. Can you tell us what the future holds for public procurement law?
Hi, Rebecca. So, dare I say it, it's an exciting time to be a procurement lawyer. Although not much has changed in the short term, as James has explained already, pretty much everything is up for grabs over the medium to long term. As you mentioned, this is because the government has published a new green paper setting out, it's fair to say, quite a radical vision for transforming public procurement going forward. Although much of the devil will be in the detail, it's clear that the government is looking to speed up and simplify public procurement, which is not surprising given that procurement processes have often been criticised in the past for being overly slow, overly bureaucratic, and not good at delivering public value for money.
But surely that can only be a good thing.
Yes and no. The impetus for change can cut both ways. One of the criticisms of the existing procurement regime made in the Green Paper is that it's often the choice of procedure that drives the procurement, rather than the other way around. Logically, it of course makes sense to think more about what you want to buy rather than how you want to buy it, and design the system around the actual needs of the public sector. However, the complexities of the existing regime can mean that the procurement can turn into a bit of a box-ticking exercise for the public authority, whether that's at central government or at local authority level. We've all heard stories when the government has ended up procuring products or services that just haven't been considered fit for purpose. To the extent that the new rules can align the processes more clearly with commercial outcomes, that must be welcomed.
All sounds good so far.
Yes, but, and it's a big but, more flexibility entails less legal certainty. By giving public authorities more discretion as to how to structure their procurement needs, it may become harder for bidders to challenge when the process goes awry, at least from a supplier's perspective. This is compounded in the Green Paper by the many, many references to new government guidance being issued, rather than black letter legislation, which may encourage some cash-strapped authorities to sail closer to the wind.
So, are you saying that it's going to be harder to challenge unfair procurement decisions?
That's certainly a possibility. It's never easy for any supplier to bite the hand that feeds them, given how costly and time-consuming it is to go to court. But there has been a trend more recently for legal challenges to be brought. The government seems to be well aware of this, and certain of the proposals in the Green Paper are directly aimed at trying to reduce the number of legal challenges. For example, by capping the level of damages available to aggrieved bidders, even where the process for awarding the contract has been manifestly unfair.
I doubt the public authorities will object to that.
I doubt so too. And there are a number of other proposals which are certainly aimed at facilitating the award of contracts to the right supplier. The expectation being that giving public authorities better tools to assess past performance, they are less likely to select unreliable suppliers going forward. There's also a push in terms of generally raising the bar on the standards expected of all suppliers to the public sector. For example, by using the procurement rules to help tackle fraud, tax evasion, and other forms of economic crime.
So you've talked a lot about the impact on suppliers to the public sector. What about the public authorities themselves?
That's a fair point. The Green Paper also raises the game in terms of the expectations placed on the public authorities themselves. They will be expected to upskill their procurement functions in order to avail themselves of the full flexibility associated with the proposed changes to the existing procedures. The public authorities will also be expected to monitor suppliers based on set KPIs and publish procurement data in line with the Global Open Contracting Data Standard in a machine-readable format accessible to all. This push for additional transparency, far beyond what is currently required, is again to be welcomed and reinforces the original remit of the procurement rules to combat corruption associated with the award of public contracts. Finally, there's also a manifest expectation that procurement strategies are aligned with central government priorities such as tackling climate change and helping communities recover from the COVID-19 pandemic. The Green Paper talks of a, and I quote, clear golden thread running from these priorities to the development of procurement strategies, whether at national or local level.
So, did Britain need to leave the EU for all this to happen?
The short answer is probably not. A number of the proposed reforms, for example, to the remedies available, could have been implemented without Brexit. But clearly that's not the current UK government's view. The ministerial forward to the Green Paper calls the end of the transition period as, and I quote again, a historic opportunity to overhaul our outdated public procurement regime. This theme is played out again and again in the Green Paper, which unfailingly points out where the direction of travel on any particular issue will require divergence from EU rules. What's clear, though, is the procurement landscape is undergoing its biggest changes since, well, public procurement first came onto the scene in the 1990s. And given that public procurement accounts for, on government estimates, about 1/3 of all public spending in the UK, maybe it's time for a serious rethink of the current regime.
Sounds like it might be. Thanks, Warsha. So to sum up?
To sum up, it's revolution, not evolution, at least as far as the public procurement rules are concerned.
That certainly sounds familiar. So thanks to you both for giving us this invaluable overview of UK public procurement post-Brexit. I know we're all going to be watching the changes to the current landscape with great interest. And that concludes this podcast. Please do visit our website, www.mayorbrown.com, as well as our 1000 portal for more commentary on Brexit and to listen to other episodes in this podcast series. And for further information about any issues raised in this podcast, please don't hesitate to contact Warsha or James in Mayor Brown's Public Procurement Group. Thank you for listening.
Thank you for listening to our podcast. To learn more about other Mayor Brown podcasts, please visit mayorbrown.com/podcasts.